we follow the breaking news from Georgia, we're also monitoring two big developments in a couple of other Trump cases. The New York hush money case that was set to start a week from Monday is now almost certainly to be delayed by at least a month. And while the judge in the federal classified documents case denied one of Trump's motions to dismiss the case yesterday, just hours after a hearing, she's also still yet to rule on a second motion to dismiss that was discussed at that hearing yesterday. Back with us now, Lisa Rubin, Danny Cevallos, and Dave Ehrenberg. Lisa, let's start with the hush money case. Trump's lawyers are now asking for a 90-day delay. District Attorney Alvin Bragg says we'd be okay with a 30-day delay. Bring us up to speed as to what has happened.
Okay, so we heard from the District Attorney's office first yesterday, but the real order in which this happened was that Trump's lawyers asked either for dismissal of the whole case or a 90-day adjournment based on a series of what they characterized as discovery violations in the case, namely that they were served belatedly with items that they believe are relevant evidence to their defense. That not only includes 104,000 pages to date of evidence relating to Michael Cohen's prosecution by the Southern District of New York on campaign finance charges, but they also say that they were belatedly served with some other things. They include, for example, information about the upcoming documentary Stormy, which is supposed to air on the Peacock Network next week. They say that constitutes a prior statement by a trial witness that the DA's office is required to turn over to them. Danny knows well, any prior statement by a trial witness is critical evidence for a defense team. So they are asking either for a dismissal or a 90-day adjournment. The DA's office came back yesterday and said, we'll agree to 30 days because we are just as surprised as you are that the Southern District of New York, again, the U.S. Attorney's Office here in Manhattan, an arm of the Department of Justice, is suddenly giving you evidence about Michael Cohen's prosecution that they refused to even us many months ago when we approached them for much of the same stuff. So there are some questions about why the Department of Justice here in Manhattan is suddenly agreeing to give to Donald Trump evidence that the DA's office itself requested many months ago, did not receive, and therefore was not in a position to turn over to defendant Trump.
So there's a lot of finger pointing going on right now as to who dropped the ball here. I guess it sounds like, bottom line here, Danny, the Southern District of New York had some evidence that the DA would have loved to have gotten from them from their case involving Michael Cohen. The Southern District Attorney's Office, Southern District of New York's office, didn't turn it over to the Manhattan District Attorney's Office. That means the SDNY also was withholding that evidence from Trump's lawyers, and that is the root of the problem. So why wouldn't the SDNY have turned over this additional evidence earlier?
There's some blame that could probably be assigned to three different sides here. But the general rule is this. You start with the rule that in criminal cases, discovery is a little more limited than it is in, say, civil cases. But in terms of discovery, the Manhattan DA's office is technically really only required to hand over what they have. They can't hand over things that they don't have. They're not required to go out and look for things if they don't have it and if they're not going to use it and they didn't know it existed. Certainly not if they don't know it exists. Now, while both are prosecutors, the Southern District is a federal part of the federal branch, and the Manhattan DA's office are state prosecutors. And contrary to popular belief, they're not always working closely hand in hand. In fact, if you ask some candid prosecutors in the Manhattan DA's office, they might say that sometimes federal authorities do not cooperate with them at all. And guess what? They don't really have to because of the supremacy clause of the Constitution. They don't have to listen to things like state court subpoenas or phone calls from the Manhattan DA's office or from the NYPD. They do what they like. So they turn over documents, the U.S. Attorney's Office, when they like, and in their judgment, they are now turning those documents over. Arguably, they never had to in the Manhattan DA's case. And if the Manhattan DA is learning about it for the first time now, there's probably no discovery violation. But if it's about documents that everybody should have known existed, if, for example, they dealt with the Michael Cohen prosecution, which happened years ago, then maybe there's some blame to be assigned to everybody for knowing that they were probably out there somewhere. But ultimately, the Southern District does what it wants when it comes to turning over documents.
And the bottom line is now the judge has to make a decision on how long the parties need to look at these additional documents and records that could be germane to the case here in New York. Meantime, Dave, back in Florida, we were covering that all day yesterday. Judge Aileen Cannon has now denied one of Trump's motions to dismiss the classified documents case, but she didn't rule on the other. So there were two motions discussed yesterday. She rules on one, says we're going to deny that request. The other one is still out there. Why are we waiting on the second one?
Well, it's good to be back with you, Anna. You know, these both are loser motions, but Trump can win by losing by continuing to delay the matter. Look, she can just rule on it whenever she can. She took it under advisement, and she will eventually reject it. But the bigger issue is when she comes out with the ruling on dismissing the case, if she decides to dismiss the matter in the middle of trial, then double jeopardy attaches, and the Jack Smith is not able to go to the 11th Circuit and get it overturned. And that is the problem. So right now, Jack Smith won a temporary victory because she said, well, I'm going to deny your motion to dismiss, but I'm going to allow Trump to raise it again later. And if he does, and he will raise it again later, and if then Judge Cannon decides to rule for Trump, then Jack Smith is SOL. That's a technical legal term, Anna. And so that's the problem here. So let's not chalk it up to a victory. So far, Judge Cannon has been giving Trump and his legal team pretty much all that they have wanted.
Judge Cannon did seem skeptical, though, about at least the second argument to dismiss, the one about Presidential Records Act. Danny, do we have any sense, though, of how or when she'd actually rule on that? Does she have to rule on that motion to dismiss at some point?
The most common question asked to people like me, Lisa, and Dave is, how soon can we expect to hear that? And the answer is, beats me, because judges can decide these things whenever they like. Sometimes, when, for example, it's Bush v. Gore, the Supreme Court can move very quickly. Other times, these things take a long time. But I just want to build on what Dave just said, because I've heard this a lot from my criminal defense colleagues. Trump may not realize that Judge Cannon is maybe helping him by denying these motions. What Dave said is so significant, is that if, let's say, for example, Judge Cannon were to grant both these motions right now and say, motion granted, the case thrown out. Well, you know what would happen? The government can still appeal that. It would go up on appeal, and probably Trump would lose at the appeals courts. But instead, if it goes to trial and it's a judgment of acquittal or an acquittal outright by the jury, there are no comebacks. That is the end of the case. So some of my more conspiratorial-minded colleagues in the criminal defense bar were contacting me and saying, hey, she's helping him. Now, obviously, I don't take that view that she's actively helping him, but procedurally, the net effect by denying these motions may ultimately be better for Trump. It may be better for Trump ultimately that she denies these motions now, preserves his right to appeal them later on down the road, but opens up the opportunity to raise those same arguments, she literally said so, at trial and move him closer to an acquittal. And from that, there is no appeal.
This is all so fascinating. I feel like a law student every day that we do these stories. Thank you all so much, Dave Ehrenberg, Danny Cevallos, and Lisa Rubin, for offering your expertise and guiding us through this.